Consumer reporting agencies have a significant amount of personal information about consumers. This information is invaluable in assessing a consumer's creditworthiness for a variety of products and services, including loan and deposit accounts, insurance and utility service, among others. Access to this information is governed by the Fair Credit Reporting Act to ensure that it is obtained for permissible purposes and not exploited for illegitimate purposes. The Fair Credit Reporting Act requires any prospective user of a consumer report, for example, an MLO, to have a legally permissible purpose to obtain a report. We will cover legally permissible purposes in just a bit. Users of consumer reports, such as mortgage loan originators, may obtain pre-screened consumer reports to make firm offers of credit or insurance to consumers, unless the consumers have elected to opt out of being included on pre-screened list. The Fair Credit Reporting Act contains many requirements, including an opt-out notice requirement when pre-screened consumer reports are used. The notice to opt out must be clear and concise and offer the consumer the opportunity to prohibit all solicitations, as well as the types of entities and information covered, and which delivery modes the consumer wants to prohibit. The consumer's choice to opt out will be effective for no less than 5 years from the date on which the consumer makes a decision, unless the consumer rescinds the prohibition. When the opt-out period runs out, the consumer must be given the chance to extend the period for at least another 5 years before the affiliates can begin sharing information for marketing purposes. Additionally, this notice can be included with any other notices required to be given to the consumer by law. This rule does not apply to a mortgage loan originator that has an existing business relationship with the consumer to whom it is marketing, to a mortgage loan originator that has a relationship with the consumer through the consumer's current employer or through the employer-sponsored benefit plan, to a mortgage loan originator performing services on behalf of an affiliate. However, this exception will not apply if the affiliate would not be allowed to, by law, to solicit the consumer, to a mortgage loan originator that is responding to a communication initiated by the consumer, to a mortgage loan originator that is responding to solicitations authorized or requested by the consumer, or to any mortgage loan originator whose compliance with this section would prevent that mortgage loan originator from complying with any provision of state insurance laws pertaining to unfair discrimination in the state in which the mortgage loan originator is doing business lawfully. Before we move on, we want to cover MLO procedures regarding consumer reports. Given the preponderance of electronically available information and the growth of identity theft, mortgage loan originators should manage the risk associated with obtaining and using consumer reports. MLOs should employ procedures, controls, or other safeguards to ensure that consumer reports are obtained and used only in situations for which there are permissible purposes. Access to and storage and destruction of this information is dealt with under a mortgage loan originator's information security program. However, obtaining consumer reports initially must be done in compliance with the Fair Credit Reporting Act.